次の講演は東アジアとヨーロッパにおけるプライバシー保護とデータ侵害インシデント対応規制についてジョイ・ホーさんとビッグ・ファンさんにお話しいただきます。この講演ではすべてのインシデント対応は適用されるデータ保護法に準拠しているだろうかということや、多国籍企業はコンプライアンスを確保するため D のような方法を使い危機に対処していけるだろうかというようなことについて言及いただけるようです。お二人からは今回のテーマについて動画をいただいております。Our next session is Privacy Protection and Data Breach Incident Response Regulation in East Asia and Europe. Please welcome our speakers, Joy Ho and Vic Ho.
Good afternoon, everybody. We are going to start our presentation of Privacy Protection and Data Breach Incident Response Regulation in East Asia and Europe. I'm Joy. I work in Lai Corporation as a privacy counsel and major in information security and data protection law. My partner is Vic, an application security engineer who is working mainly on web security and blockchain security. There is our agenda. This paper starts from the regulation of Taiwan, Japan, and Thailand, including the personal information definition and the comparison of data breach incident response regulations in the three countries. You can see the legal trend of data protection in East Asia. Also, since the Thailand data protection law is quite similar to the general data protection regulation of European Union, which is known as GDPR. These far-reaching data protection rules and the risk-driven type of legal requirements are also introduced to you. Followed will be the topic, data breach incidents in real world. We will show you how did the enterprises handle the data breach incidents, and if their handling process is compliant to the regulations in their jurisdiction. The final part is our suggestions of data breach incident response. This paper narrows down the topics in the scope of personal data breach incident response. Here are the 4 issues. What shall a transnational enterprise do while the personal data breach has happened? How could the company interact with the data subjects? Does the company have legal obligation to report the data breach to governmental authorities or any other stakeholders? What is the international trend of the incident response mechanism? We are trying to reply to the 4 issues. We are analyzing the legal requirements and the recent practices in different countries. We are going to start from introducing the definition of personal data. First of all, in Taiwan, the Article 2.1 of Taiwan PDPA has ruled that personal data is defined as any information that may be used to directly or indirectly identify a natural person. For example, a natural person's name, date of birth, ID card number, passport number, fingerprint, family information, education background, criminal records, contact information, financial conditions, and so on. Also, in Japan, the personal information is defined as information about the living individual, are sufficient to distinguish specific individuals based on the name and birth months contained in the information descriptions, including the personal information which could be used to identify individuals by mapping different information. In EU, Article 4 of GDPR wrote that Personal data means any information related to an identified or identifiable natural person, known as data subject. In Thailand PDPA defines personal data as any information relating to a person, which enables the identification of a person, whether directly or indirectly, but does not include the information of deceased persons. I'm now introducing the regulation of personal data breach. First of all, you can notice that Taiwan PDPA defines personal data breach as any personal data is stolen, disclosed, altered, or otherwise infringed upon due to a violation of the PDPA by a government or non-government agency. Also, there are other regulations ruled how to handle the personal data breach, especially the obligation to notify data subjects. I will introduce them later. In Japan, there are no specific legal requirements regulating how to handle personal data breach. In European Union, personal data breach has been divided as 3 categories, including confidentiality breach, availability breach, integrity breach. Confidentiality refers to protecting information from being accessed by unauthorized parties. In other words, only the people who are authorized to do so can get access to those data. Imagine your bank records. You should be able to access them. And the employees at the bank who are helping you with a transaction should be able to access them, but no one else should. A failure to maintain confidentiality means that someone who shouldn't have access could get the data through intentional behavior or by accident. Availability means that information is accessible by authorized users. Failure of availability, such as denial of service, will bring down the server, making the website unavailable to legitimate users. Integrity refers to ensuring the authenticity of information, that information is not altered, and that the source of the information is genuine. In Thailand, the PDPA ruled that in the event of a data breach, data controllers must report the breach to the regulator without undue delay, and in any event without 72 hours of becoming aware of it. Now I'm going to show you the comparison of data breach incident response regulation. I will start from Taiwan, Japan, then EU and Thailand. Article 12 of Taiwan PDPA ruled that if personal data breach happened, the data subject shall be notified via appropriate means after the relevant facts has been clarified. Article 22 of Enforcement Rules of the PDPA also rules that a notification given via appropriate means shall be understood as a notification that is given in a prompt manner, via verbal words, in writing, over the phone, via text messages, email, fax, electronic documents, or any other means that can effectively make the information known or available to the data subjects. However, if such notification costs too much, taking into consideration the technical feasibility and privacy protection, a data collector may notify the data subjects through the internet, the media, or other proper and public means, for example, the newspapers or the website. The content of notification shall include the facts pertaining to the data breach and the response measures already adopted to address such breach of personal data. There is no exceptional situations. Once the data breach happened, there is already a legal obligation to notify the data subject. It doesn't matter if the breach is risky to the data subject or not. You may notice that there are no relevant articles about the data breach incident response regulation in Japan. It is not legally required to report a data breach incident to the Personal Information Protection Commission, known as a PPC, or to notify the relevant data subjects. However, the PPC issued guidelines recommending that this notification be made, and it is a market standards practice to report data breach incident in Japan. Not doing so and instead having the breach discovered publicly would have a potentially massive negative impact on brand image and reputation. In addition, the PPC guidelines provides the companies 3 suggestions. 1. Make necessary investigations and take any necessary preventive measures. 2. Make public the nature of the breach and steps taken to rectify the problem. 3. Send a voluntary notice to the data subject of the breach or publish the data breach if appropriate and necessary. Also, if a factual situation demonstrates that the personal data is not actually disclosed, the notice to the PPC or any other relevant authority is not necessary. For example, if the company has encrypted the data or otherwise secured the data in such a way that it has become useless to the third parties, it is not necessary to do any notification. By European Union, if a data breach occurs, and it is likely that it poses a risk to an individual's rights and freedom, the data controller has to notify the supervisory authority without undue delay, and at the latest within 72 hours after having become aware of the breach. If it is the data processor being aware of the data breach, the data processor must notify the data breach to the data controller. If the data breach poses a high risk to those individuals affected, then they should all also be informed. Unless there are effective technical and organizational protection measures that have been put in place, or other measures that ensure that the risk is no longer likely to materialize. The content of notification shall describe the nature of the personal data breach, including the categories and approximate number of data subjects concerns. 2. The name and contact details of the data protection officer or other contact points where more information can be obtained. The content of notification shall also describe the likely consequences of the personal data breach and the measures taken or proposed to be taken by the controller to address the personal data breach, including measures to mitigate its possible adverse effects. About the exceptional situations, if the personal data breach is unlikely to result in a risk to the natural person's rights and freedoms, there's no obligation to notify the authority or the data subjects. By Thailand, in the case of a personal data breach, the data controller must notify the PDPC of the breach without undue delay, and in any event within 72 hours of becoming aware of it, except where the personal data breach is unlikely to result in a risk to individuals' rights and freedoms. Under the Thailand PDPA, if a personal data breach is likely to result in a high risk to data subjects' rights and freedoms, the data controller must notify the breach to data subjects. Currently, the Thailand PDPA does not provide requirements for the notification of personal data breaches. However, such a requirement will be prescribed in the future in a supplemental regulation of the PDPA. Also, the Thailand PDPA does not provide any exceptional situation. However, PDPC may make a supplemental regulation ruling the exceptions in the future. The PDPA also states that data processors must notify data controllers of the personal data breaches that have occurred, but does not specify a time frame.
Hi, I'm Vic. Now we're going to introduce 4 data breach incidents in 4 countries. The first case is happened in Taiwan. The data controller is militaries of civil service, which is a department of Taiwan government handling promotions and retirements. The incident disclosure date is at 2019 June. Five Eyes notified Taiwan government that there is a data breach incident. Someone is selling the Taiwan government's employees' data in darknet. The breach data contain name, personal ID, address, and promotion records from 240,000 employees in normal and sensitive departments during 2005 to 2012. The response and the announcement from Taiwan government said that the data is from the abandoned system which had been compromised by attackers. The government will improve the protection of personal data protection in regards to the law. And according to the response and Taiwan PDPA, the institution which collect personal data have to notify data subject after the relevant facts of data breach has been clarified. But sadly, because 2 members in my family are on the list, but they didn't receive any kind of notification, so I think it's not a good way to do the incident response like this, and it's not fit to the Taiwan PDPA. The next one is happened in Japan. Data controller is Mitsubishi. The incident happened in 2019 June. Attacker used CB 2019-18187, which was a zero-day LAN, a directory traversal, and arbitrary file upload vulnerabilities in Trend-Micro Office Scan antivirus to attack Mitsubishi Office. Attackers are believed from China TIC, which is a APT group. They stole about 2,000 resumes, employees' data, internal data. Mitsubishi disclosed the scope and announced that they will start to notice victims. And according to Japan PDPA, it's not legally required to report a data breach incident to PBC or notify the data subjects. But there is a guideline as Joy mentioned, they recommend to notify their subjects due to the market standard practice. So Mitsubishi did a really good job about disclose the all details and set a windows for the data subject. The next one is an example in Thailand. Toyota was attacked by Vietnam APT-32, as known as Ocean Lotus or Cobalt Kitty. The scope of breach data is global 3.1 million customers' data, which contain name, birth date, and job information. Toyota Thailand official website has announced that they were attacked, but there is no other information for instant response that I can find. Although Thailand PDPA is not in effect yet, according to the law, after having become aware of the data breach, data containers should notify data subjects who with high risk to damage rights and freedoms no later than 72 hours. So if the Thailand PDPA was in fact, they should notify data subjects for this. In 2018, British Airways suffered a significant breach of their systems with personal and financial details of 0.43 million customers being impacted, making it one of the most severe cyber attacks in UK history. One of the official websites was redirected to malicious website by attackers. The breach data contained name, booking record, credit card numbers, and address. The incident response and the announcement said that they will notify victims as soon as possible through email. And according to GDPR, they have to notify data subject in 17 hours, but they didn't. So the fine can be up to 4% of yearly revenue. So about 230 million USD, which is the highest fine the ICO have ever leveled at a company for data. They fined 25 million USD as the final result, considering the COVID-19 situation and the reducing of the revenue. After we go through these 4 cases and their incident response, we are going to look closely to incident response and regulation. International trend of handling data breach is divided to 2 types, risk-driven and regulation-driven. First, risk-driven type, for example, GDPR and Thailand PDPA. The notification obligation is based on the risk assessment. The second one, regulation-driven type, for example, Taiwan PDPA belongs to this type. It's ruled that companies need to notify data subjects while there's a data breach, but there's no exemption or consideration about the risk. Therefore, if it's possible to check all legal requirements in different jurisdictions, the company could check first the type of the regulation, as we mentioned. Then you will know if you need to add the risk assessment into the process. NIST and SANS incident response flow are very common and acceptable for companies. The companies import this system and customize it as an internal incident response flow. So according to the PDPAs we have mentioned and GDPR, for risk-driven type, like Thailand PDPA and GDPR, the company may need to notify data subjects who with high risk to damage rights and freedoms no later than 72 hours. But as we follow the NIST and SANS incident response flow, when is the urgent 72 hours start to tick? The answer is pink one. The answer should be preparations, but the GDPR requires that you have to provide some elements in the notification to data subjects. So when can the company actually collect the necessary information for that notifications? Actually, it should be green because we have 4 elements in the notification that we have to collect before we send it to data subject. The first, the categories and approximate numbers of data subjects concerned. The second one is the contact point. The third one is the likely consequence of the breach. And the last one is the measure taken or proposed to be taken. So we combine the regulations and the incident response flow that we have to start analyzing as the preparations and finally send the notifications to data subject when we finish the analyzing. Almost all the data protection laws require data controllers and data processors must provide appropriate security measures in order to prevent loss, access, use, change, revisions, or disclosures of personal data without authorizations. An incident response plan would be an important part of appropriate measures to manage data protection and legal compliance. But as Japan PDPA mentioned, they recommend to follow the market standard practice, which I believe should mean the honesty and transparency. Win the trust of your customers, or you can say the trust of your data subjects is always important. Data privacy has become a key issue over the past several years.